there we are. There's the electronic voice to tell you that you're being recorded. So today's session is focused on green public procurement. The POGO Club, by way of background, for those of you who don't know or haven't been for a while, is jointly hosted by the Government Outcomes Lab at the Blavatnik School of Government and the Faculty of Law in Oxford. And our focus today is on the integration of social and environmental goals into public procurement, including contract management, as is often the case in these sessions, taking a broader view of procurement than just the narrowly defined process of awarding the contract. So we're going to be looking at mechanisms of green public procurement in the US, the EU, and South Africa. So this encompasses deciding what to buy, trying to change how procurements are run with new evaluation criteria, or focusing who to buy from based on contractor qualifications, efforts to shape supply chains, and so on. And our panel, which is a great panel with some very considerable expertise on it, is going to compare different approaches in their respective jurisdictions and comment on the opportunities and challenges associated with the different mechanisms of green public procurement. So that's our focus for today. So without further ado, I'm going to hand over to our first speaker, Abby Semple, who is well known to many of you in the group. Please do think about your questions and comments for Abby as we go through, and please be active in the chat as well, and our panelists may join in with that too. So please feel free to store up questions for later, but also to contribute them as we go along in the chat. And there's Rory just opening that up for us. Abby, over to you.
Thanks so much, Anne. And I have to say, I'm really glad we're having this meeting today because I actually woke up in the middle of the night last night. I don't know if this happens to anyone else, but sort of seized with the fear of what is the point of it all? You know, why are we trying to do all these things through procurement, and is it having any impact? And shouldn't we just introduce a carbon tax on everything, and that would be much easier and more impactful? So you know, whenever I have fears like that, it's helpful to come to a group like this and either confirm my fears or perhaps to reassure myself that some of what we're doing anyways does have impact, that it's being done internationally, and that if we are doing things in a way which is suboptimal, we perhaps have the chance to improve them over time. So I've been asked to cover the EU angle for today, which I will attempt to do in the 10 minutes which has been allocated. And yeah, happy to take questions after we've heard from the other speakers as well. So we've been asked to look at the what, the how, and the who. So I'm going to begin with the what, and I thought it would be useful if I just put maybe one, perhaps two slides up, because it is a bit of a complicated landscape when we talk about EU public procurement and what we are able to do, or in some cases forced to do, in terms of sustainability. And in previous sessions, we've had a chance to reflect on what's possible under the EU procurement directives. But I thought for today's session, it might be worthwhile highlighting just some of the more recent legislation adopted at EU level, which has a more or less direct impact on what we might consider the sustainability impact of public contracts. So I've attempted to list what I see as the most relevant legislation adopted over the last year or so on this slide. Some of it very recent indeed. So the Energy Performance of Buildings Directive, which is of course a revision. There is an existing Energy Performance of Buildings Directive in place. The ... means it hasn't yet been actually published in the official journal, so it's just in the final stages of being adopted by the EU institutions. But it is setting new and very ambitious requirements in terms of public buildings. So the headline being that all new public buildings would have to be zero emission from the 1st of Jan 2028. And behind that, there are a number of additional requirements around things like use of renewable energy, and the planning and systems that go into buildings as well. So that's one example of a requirement for sustainable procurement. It's nowhere mentioned in the procurement directives themselves, but it will very, very shortly become binding on public bodies across the European Union. Another instrument of similar nature would be the Energy Efficiency Directive. This covers a broader range of products and services, so everything from things like ICT equipment through to things like tyres, and also service contracts where those are provided. And again, a number of sort of minimum requirements being broadened out across the entire public sector, whereas previously they only applied to central government bodies. Slightly narrow in its focus, but arguably going further in terms of what it tries to do, is the batteries regulation, which was adopted last year. And this is a really interesting one because obviously, if you look at something like transport, we've seen a strong push, obviously, towards the electrification of transport. But as a consequence of that, we are buying vehicles with ever bigger, heavier batteries in them. And I think most people are aware of the rather profound environmental and social impacts associated with battery supply chains. So the batteries regulation is an attempt at EU level to deal with that in a number of different ways. So many of the requirements apply to the industry as a whole. So if you want to place a battery on the EU market, you have new due diligence requirements covering both things like supply chain, human and labour rights, but also the sourcing of the raw materials going into those batteries, as well as their environmental performance in operation and what happens to them at their end of life. It also contains requirements set out in Article or Regulation 85, specifically on procurement. So in terms of the specifications and award criteria that contracting authorities need to apply when they are purchasing batteries. Just a few others to mention as well. We have the EU Deforestation-Free Products Regulation, also adopted last year. Again, this is an industry-wide one, so it's not specific to public procurement, but it targets some key commodities which we consume quite large quantities of in Europe, including under public contracts. And I suppose the thing for public bodies to be aware of here is the potential for disruption to supply chains if operators are not able to comply with the requirements under the EUDR, which are around things such as being able to provide geolocation data to show where exactly in the world a particular commodity has come from. Finally, then we have the Corporate Sustainability Reporting Directive and its sister directive, which looks very likely now to be adopted, the Corporate Sustainability Due Diligence Directive. These, again, go much more widely than public procurement, but they will have an impact in terms of what we ask for as part of sustainable procurement, because increasingly firms will have to be reporting against the standards set out under these directives. So that is going to influence the type of data that they have that we can ask for, as well as what they are requiring from their own supply chains. So as you can see, we have, across a number of different sectors or a number of different, I suppose, areas of concern, really quite far-reaching requirements being set out in European law. And I would say, for the most part, this goes to the what. What is it that we are purchasing? Where does it come from? How has it been produced? How does it perform during its lifetime? What happens to it at its end of life? So all of those sort of circular economy and broader sustainability questions being addressed by this legislation. So that is, I suppose, an update on the sort of what side under EU law. The who side remains, I would say, an underdeveloped area in terms of EU procurement. So we have not seen very strong use of restrictions on bidders under EU law. There is provision for it under the directives, and there are obviously certain grounds under which you can exclude bidders. However, the basic principle under EU law remains this idea that anyone should be able to tender, and that we shouldn't really be putting in place corporate requirements, requirements, for example, around corporate policy, and sort of using that to select or to limit who can bid for a particular contract. And this, I should say, is in distinction to some of the approaches we're seeing in the UK. And also, as I understand it, in the US, which hopefully Chris will be able to touch upon in his presentation. So, for example, requirements around something like net zero or disclosure requirements, currently not part of European law when it comes to procurement, because those would be sort of corporate-wide obligations, which under the link to the subject matter requirement, we are not generally able to apply under European law. The CSDDD is an interesting, I suppose, caveat to that, in that it does refer specifically to exclusion of bidders. However, when you look at it more closely, it is really just operating under the existing Article 18.2 of the procurement, the public sector directive, which allows us to exclude bidders based on non-compliance with environmental or social legislation. Now, obviously, we don't know yet fully what that's going to look like in practice, or indeed, whether there may still be changes prior to the adoption of that directive. So we have the what and the who. The how is probably what really interests me, and which I see as probably the most promising area for development under European law. And when I talk about how, you can look at that from a number of different perspectives. You can say, okay, what type of procedures are we using? What types of contract or framework are we awarding? But also really vitally, this contract management or contract performance phase. And as I see it, we still have a really big underdeveloped potential in terms of contract stage incentives, penalties, targets, ways of working with contractors once they are in place in order to deliver specific environmental or social objectives that we want under the contract. And I think it's really interesting that we have so much focus on the tendering stage, on the procurement. We still have relatively little focus on the contract delivery phase. And one of the reasons why we might want to reverse that focus stems from some of the issues we're having in Europe around competition for contracts, around new market entrants. There was a rather damning report published by the European Court of Auditors towards the end of last year, looking at the fairly low levels of competition for many contracts across Europe, as well as a single bidder problem in many member states. And I think that kind of speaks to the fact that we've had very strong focus on requirements for individual tenders, and not so much focus on what actually happens during the contract itself. One of the potential consequences of that being that bidders find it hard to tender for contracts. They perhaps find it difficult to respond to some of these contract-specific requirements at the tender stage, whereas once they had their foot in the door, potentially they might be able to do that and to invest and respond to those type of requirements as part of contract delivery. So perhaps an area of hope and further development. One that isn't currently very, very heavily regulated at all, which is not necessarily a bad thing. But interested to hear from our other speakers about any sort of more contract delivery or contract performance phase developments in their jurisdictions.
Fantastic. Thank you very much indeed, and perfectly timed. I think we're handing over next to Chris.
Thank you very much, and thanks very much, Abby. First of all, I want to apologize to the audience that I'm sitting in a parking garage in New Jersey. I had to drop my wife off for a train in New York, so I apologize for the circumstances here. What I want to do is cover three separate things today with you. One is the piece that I did with Marta Endoff that Rory very kindly posted. The second is a catalog of best practices that was to our surprise, and we didn't know about it when we published the piece a few weeks ago. A catalog that was put together by the European Commission and the U.S. Trade Representative on best practices in sustainable public procurement, and that's available as well. And Rory posted that as well on the website. The third thing I want to talk to you about is a new rule that was published on very recently on April 22 in the Federal Register. The citation for that is 89 Federal Register 30212. 89 Federal Register 30212. And this is an important final rule that sets forth standards that federal agencies are to apply when they're making procurement, when they're making purchases. It's a very comprehensive rule. I'll be touching on it briefly as I go through, mindful of the time. So the strategies that Marta and I laid out were strategies that others, including Steve Schooner, have pointed to, strategies of trying to affect sustainable public procurement through planning. That's, for example, that's something that the Brazilians did very aggressively in their recent changes to their procurement laws. Vendor qualifications, Abby touched on that. There is a pending rule regarding in the United States regarding the qualification, or what we call responsibility of contractors, saying that for contractors that have over $7.5 million in obligations per year from the government, they are required to chronicle the greenhouse gas emissions. Now, I hope during the reflections period, we can talk briefly about what's going on in the European Union with regards to requiring that large companies register or quantify their greenhouse gas emissions. That initiative has largely stalled because of likely litigation in the United States in the Securities and Exchange Commission. The requirement that the publicly traded companies chronicle their greenhouse gas emissions. It was also scaled back by the SEC during the regulatory process. In the federal sphere, the pending rule would require that, and the idea was they could piggyback on what's being done in the securities markets, that large companies could present their data regarding greenhouse gas emissions. The setback in the SEC's set that back, and also, very importantly, in the National Defense Authorization Act for fiscal year 2024, Section 318 of that National Defense Authorization Act, which is discussed, the National Defense Authorization Act is discussed on my blog, publicprocurementinternational.com. Section 318 said that the Defense Department can't demand of its contractors information regarding those greenhouse gas emissions. It blocked it permanently with regards to non-traditional defense companies, and for a year regarding traditional defense companies. So as a result of these various initiatives from the right to check the expansion of these requirements, we're seeing a stalling of this initiative to focus on contractor qualification, what Abby was referring to before, as a pathway to sustainability. Another pathway is through eco labels. I'm going to be talking about that because it's a very important part of the final rule that came down. So the greenhouse gas emissions chronicling rule is stalled for the political reasons I mentioned, but the final rule that came down focuses very heavily on eco labels, one that was published on April 22. Another approach is to have specific product requirements. That was swept up in the April 22 rule as well. And the last is to use training or management. I'm going to turn back to that in just a minute. With regards to the catalog that was put together by the U.S. Trade Representative and the European Commission, we're going to be having a webinar on that on May 13th. The information on that webinar is available on my blog, publicprocurementinternational.com. You can click through that if you want to register for that, publicprocurementinternational.com for the May 13th webinar. We're going to have Lucian Cernat from the European Commission, while the representative from the U.S. Trade Representative joining us to discuss that catalog. The catalog is very interesting because it gives examples of best practices on both sides. And those examples are very useful. It does not, interestingly, even though it was put together by trade units in Brussels and in Washington, it does not discuss the trade barriers that can arise from different eco-label standards. And so that'll be a major issue, whether or not we can address those trade barriers that invariably do arise because of differing eco-label standards. The catalog is worthwhile taking a hard look at it. I cite some interesting examples. For example, in Norway, a very successful effort to contain the emissions from a major ferry service in Norway. And that really is a good illustration of letting the contractors run, letting the vendors come forward with innovative solutions. And that worked very successfully in Norway. The point of the webinar, what the catalog is really an effort for political purposes, certainly in the United States, because to bring forward, can you hear? To bring forward various successes success stories in sustainability, but it doesn't really talk about a prioritization among different strategies. And what we're going to try to do in the May 13th webinar is talk about what we're seeing internationally is a prioritization of strategies based in part on costs. Turning quickly to the new rule that was published on April 22nd, the agencies are required to purchase to the maximum practical possibility. They're required to purchase sustainable goods, and those sustainable goods are identified through the EPA, largely through the EPA, the Environmental Protection Agency, by references to eco-labels. Interestingly, the EPA, in identifying eco-labels that would apply to specific goods, doesn't pass on them. They just adopted them. Partly for that reason, the list now is frozen as of October 2023. The EPA list won't be evolving without notice and comment. Some important elements of the rule in terms of the actual practice, how it will work, focusing on Abby's questions. The contracting official, who's in our procuring entities, the contracting official, the contracting officer, will take the lead. And so the contracting official, who may not know anything about sustainability, will have a very important role, both in assessing internally whether or not it's possible based on price, performance, and time, whether or not the agency should take an exception from these requirements, which will give the agency a lot of leeway to try to exempt themselves from these requirements. And in turn, also how those sustainability requirements might be applied to the contract. For example, there's nothing in the rule to tell the contracting officials how you might use an eco-label in an evaluation process, what weight you might give it. That's left to the agencies. And that amount of discretion could raise issues down the road. Besides leaving to the agency to decide the evaluation criteria, it also leaves to the agencies the supervision. And that raises an interesting and important question for contractors. How closely will the agencies monitor this and create potential fraud risk for the contractors who don't comply? The last thing about the rule is interesting is that it feels like a rushed effort to get things out before the election. And it wasn't, the rule wasn't scrubbed for political purposes. The rule, the prefatory materials and the rule itself, for example, don't take into account any serious account the potential cost to the contracting community, or as Abby alluded to before, the impact on the supply chain. And that creates a vulnerability for the Biden administration in the fight between Biden and Trump coming up in November. Hope I haven't run over, Ann. Thanks very much.
No, not at all. Thank you very much indeed. And last but very much not least, Gio, it's your turn.
So much. Yeah, so I mean, a very different context, South Africa, to talk to. And as a starting point, I should just say that when in South African procurement, we think about sustainable public procurement, we are and have always focused predominantly, I mean, almost exclusively on the social dimension. So in the South African context, the use of public procurement for social policy purposes is very well established, lots of rules on it. It is just a standard part of our procurement system. So wealth redistribution, pursuing equality, all of that, with detailed rules on that. So that has always been a big part of our procurement system. However, the environmental side has been largely neglected within that space. And I think one of the really interesting questions in the South African scenario is how one can leverage a lot of the mechanisms that we've created, and that's now widely accepted and I mean, if not widely understood, at least widely used for environmental purposes as well. Because in principle, if you look at the mechanisms as they've been built and designed, there's no reason why they cannot be used for environmental considerations in addition to the social ones that we're already doing. So we see in our system a very limited focus on environmental considerations. At the legal level, there's really nothing explicit on green procurement, on environmental considerations. Very disappointingly, we are currently writing a complete new public procurement law. It is about to pass through our parliament. And even in this new statute, there's really just, I think, 2 lines about real green procurement. So we're also not seeing in the new legislation really a push towards this, which is very concerning, I must say. National and provincial levels of government as a matter of practice, we don't really see much happening there. But at local government level, we do see quite a bit of movement in terms of environmentally friendly or green public procurement. And this is also significant because in the South African system, the bulk of procurement sits at the local level, not at the national and provincial level. So if you look at any metric, whether it's volume or value, it is local government that's spending the most money through procurement. So at least, you know, there is some attention at that level to local green procurement. But again, it's really limited to some of our bigger municipalities. So it's not across the board, but there are some really good examples. Now, several of our empirical studies in South Africa have now found that this absence of a clear legislative mandate and then linked to that a clear policy mandate which explicitly mandates green public procurement is really acting as a major barrier for procuring officials on the ground actually pursuing these kind of practices. It seems that you need a really very robust procuring official to take this up and start to run with it in the absence of this very clear legislative and policy mandate, even though when you look at our general procurement rules, our kind of standard generic rules, there are many places where the standard mechanisms for pursuing green public procurement can quite easily be incorporated into our system. So for example, we've got no hard rules on how specifications are to be drafted. So it is perfectly possible for any entity to use the specification drafting for the purposes of environmental policy, which we know is a very widely used mechanism. The same applies to price. So in the South African procurement system, price is the single biggest award criterion. It contributes either 80 or 90% to the final award decision. But our law, again, says nothing about how price is to be determined within a particular tender. That's completely up to the procuring entity. So there's nothing in our law prohibiting a procuring entity, for example, calling for life cycle costing as the price mechanism within that tender. But again, we're not seeing a lot of that. So there is a lot of scope, but we're not seeing it being used. If we look at the how and the who, they are really very closely linked within the South African system. And the reason for that is we've only got a very few procurement methods in South Africa, very, very limited menu. And we basically use open tendering above a threshold, a certain threshold, as the standard mechanism. And even though that would then apply, of course, to all larger procurements, a very significant portion of our public procurement practice happens below that threshold. And that for that kind of procurement, we use quotation systems or limited bidding. And in the limited bidding or quotation system, organs of state has got significant freedom and significant flexibility in deciding who they're going to invite to participate in this limited competition. And again, there are very few rules that would prohibit them from adopting, for example, environmental criteria as a guide in who to invite to participate in a particular procurement. So there's, again, a very significant opening for using that. And I'll talk a little bit about one very interesting example of this in a moment. The what, of course, specifications is the best known one. It's also in South Africa, the one that's in local government used the most. There are a number of cities that's really started doing this quite aggressively. The city of Cape Town being probably one of the best examples, where they've really did a lot of work on standardizing specifications for common commodities, common services, drawing up templates for those specifications for procuring officials to use. And I think that has been quite successful in the sense that it talks to one of the biggest challenges we've also got, and that is the capacity of our procuring officials. So we've got a highly decentralized procurement system. Every entity in the country procures for itself. We've got very little, if any, centralized procurement. But of course, that also then means that your capacity and your competence across your procurement workforce is really constrained, especially in a system like South Africa. So it's not really feasible to think that you can have a procuring official across the country being able to do quite sophisticated environmental specifications. That's just not going to happen. They're not going to be able to frame it. They're not going to be able to evaluate it. They'll probably get it wrong. So in that context, the drafting of standardized or template specifications for particular commodity groups has been really successful, and it's been a big driving force, I think, of some of the biggest successes we've seen. I want to perhaps just conclude, let me conclude on this, and I'll raise the final challenge there as well. So I think what's been quite interesting in one of the experiments is one of our cities, Nelson Mandela Bay Municipality, has played with this idea of a green procurement scorecard for their suppliers registered on their own database of suppliers, where they require the supplier to complete a prescribed scorecard, say something about the supplier's own green credentials. So not necessarily linked to the actual procurement, just in general. And using that then as a mechanism to pick suppliers when there's a quotation or limited bidding system. I think that's quite an interesting phenomenon, because it is effectively using what we call our preferential procurement regime, which is our Black economic empowerment regime, using that logic and the mechanism that we've used there, which has been a scorecard mechanism where we rate particular suppliers. We rate all companies, not just government suppliers, but then including government suppliers as well, based on their contribution to the Black economic empowerment scheme. And that then feeds into procurement choices. Now, it is what Nelson Mandela is doing is trying to extend that same logic, that same kind of approach into a green dimension. And by doing so, they're cascading the environmental policy considerations into the private supply chain as well, which I think is a really interesting phenomenon, and we'll see whether it bears any fruit. But, and this is the final point that I'll make, therein also lies one of our biggest challenges, and which is, given our economy, given where we are situated, putting too much emphasis on green commodities really puts a lot of pressure on our supply market, because we just do not have a big enough supply market in many of these areas to sensibly be able to insist on green commodities. So that is a major limiting factor for us. And I'll leave it at that for the moment. Thanks, Anne.
Fantastic. Thank you very much. And absolutely superb timing from everyone. Well done. So what happens now is we have a few minutes to collect up some questions from the audience, and then we will go back around our panel for their reflections, including, of course, their reflections on each other's comments. While you're thinking about your questions and comments, audience members, I'll abuse my position and ask one myself. So I was kind of struck in all three of our panelists' presentations that this green procurement space is an area where you get a bit more interaction between procurement-specific rules and rules that have been introduced in other areas and for other purposes. The scoring mechanism that you were just talking about, the CSDD, that kind of connection between the SEC regulation and procurement regulation. And I'm just wondering how the panelists see the sort of strengths and weaknesses of that potential greater interconnectedness between procurement regulation and other types of regulation, whether that's a good thing, a bad thing, indifferent. I'd love to hear a little bit more about your thoughts on that. Malcolm, I see, has got a hand raised. Hello, Malcolm. Malcolm, you're muted. We can't hear you.
I remember to unmute. Yes. So good afternoon, everyone. Just a few reflections. I thought the presentations have been fascinating so far, but I just want to perhaps set some context in terms of the European position. And perhaps just a reminder to people, and if you want to find the details, you can read Abby Semple's very good PhD thesis on the approval of the 2014 regulations, because there was a very strong green element in that, promoted by my colleagues in the European Parliament. And in fact, a Green member of the European Parliament did a report on what we wanted to see in the directive in 2010, and that was before the Commission had even produced a draft. So, so there is a long thread behind this. But I think what's been interesting about the legislative activity in Europe is that they've now seen that simply encouraging the use of procurement criteria in procurement is not enough. There does need to be much more specific and clear guidance given. Otherwise, you're not going to get the sort of performance improvements that you really want to achieve zero carbon. And that's something that people will have to get used to. But I do think that not enough work is being put into actual standards themselves, which can be cited in order to make those improvements. That's just a first observation. And the second one, I think the very important observation that we just heard from South Africa about the fact that there is lots of inbuilt activity at a local level in procurement. And I think that that's really crucial because I think a lot of the initiatives are coming from the bottom up. And that in democracies, electors are actually becoming more interested in challenging politicians about their procurement, their green records, and using procurement for that. And I note that, again, and this is just a closing initiative from Europe, I was at a big meeting of the European Innovation Council a few weeks ago, where they actually had a beauty contest trying out a new initiative that they're working on, and you can find it on the European website. It's called SPIN, SPIN, SPIN for EIC, where actually you had innovative small and medium-sized companies who have real ideas for reducing carbon emissions, pitching to private sector organizations and large organizations in the fields, say, of energy generation or hydrogen generation and those sort of areas. So I think that there's a bit of a porosity here between what we've done in public procurement and what also needs to happen in private procurement as well.
Fantastic. Malcolm, thank you for your input. Rory has his hand raised. I just point out to the panelists that there's a couple of questions in the chat as well when we get back round to you, Rory.
Hiya. So my question is as follows. How enthusiastic are panel members about the capacity of public procurement professionals to do some of this work? It strikes me that this work involves public procurement professionals doing more things upfront before the sort of competition. So like lots of market engagement to understand what's available in the market. And I think it also involves lots of activity afterwards to ensure that contractors actually meet any commitments that they have made. So there's a lot of more to do. And there's a new role of a sustainability officer that may be an opportunity. Shared services organizations might be an opportunity or a challenge. But certainly in the UK, local government budgets have been, reduced consistently for the last 10 years. So I think there are capacity and staffing issues there. But so the panelists, my question is, how enthusiastic are you and why so?
Fantastic. Thank you very much. And Lucky, you get the last question.
Thank you so much. And my question is very much in the same line of inquiry. Rory and I actually, I think, are of the same mind. The work and research that I do starts at the end of the contract. So in a way, it's a cautionary tale. The rules, as well-intending as they are, the capacity gap is real. And in the US, we see the same reality because I'll give you a very simple example with the Recovery Act that made it mandatory the US government's purchase US-made products. Once an audit was actually done, this was done less than half of the time. And that was because those contracting officials were given new extra work, reporting requirements, and no additional resources to accomplish that work. So now you're layering those green requirements. Unless you provide training, unless you provide resources and capacity, especially at the local level, they're not going to do it. You're going to have to trust the vendor. And that is a big problem if the vendor is motivated by profit and they say, yeah, but. So back to Abby's question, sometimes I am up at night thinking, what is the impact of these rules and laws unless you actually invest in management?
Fantastic. Thank you very much for that question. I'm sorry we've gone back round to the waking up in the night though. Let's now hear from our panelists who are free to comment on each other's presentations, pick up any or all of those questions. Roughly 5 minutes each, and we'll go in the same order. So Abby, you can go first.
Okay, thanks. Well, just first one observation, something that jumped out at me from Hugh's presentation, where he was talking about the role of the subnational governments in leading on this, and I think that very much chimes with a lot of the experience we've seen across Europe, that it has tended to be subnational buyers leading out on sustainable or innovative procurement, and central governments have tended to follow behind. So just an interesting thing to note, and I'd be really interested to hear Chris's view on what's happening at state level as well. Your question, Anne, about the interconnectedness, I mean, I think, yeah, we can say procurement well and truly now discovered by people in other policy domains as a, supposedly a means of getting things done, right? And that's so clear in the legislation under the current European Commission over the past 5 years, that it's inserted not only some of the legislation I mentioned, but also things like trade agreements, much more emphasis on public procurement as a policy tool. Not least, I would say, due to the efforts of Malcolm and his colleagues in the European Parliament 10 years ago, or 10 to 15 years ago now, I guess, in sort of raising the profile of procurement. And we see that being followed through now. So I think we have to learn to live with that, and from the perspective of practitioners, and I think perhaps we're a little bit underrepresented in terms of practitioners here today, but this point that procurement is being asked to do an ever increasing list of things. Can we do all of those things while still maintaining competition, value for money, while being efficient? Another one of the findings from that European Court of Auditors report is that procurement is now taking longer, whereas one of the ambitions for the reform of the directives was that we would simplify procedures and make them more shorter to run. So I think we do need to think about capacity, which is the question or the point raised by Rory and Lucky as well. On the contract management side, I work with a lot of public bodies who they don't have anybody whose job title is contract management. That's just not a job role within the organization. So it falls perhaps to an engineer, or perhaps to someone who just happens to be doing something that is affected by the contract, if any contract management is in fact going to take place. So I don't know to what extent that is the case in other jurisdictions as well, but certainly some of the ones I work in, that's the case. Just quickly, a couple of the questions in the chat. Alan is asking, when will green procurement be mandatory instead of voluntary under the directives? I don't know, but I think we, to some extent, we may well be looking now at reopening the directives under the next commission, obviously depending partly on the political makeup of the next European institutions. But I think we have so much which is effectively mandatory under other instruments. At the very least, there's a strong case for cross-referencing those within the European directives, within the procurement directives, so that we know where we do have mandatory obligations. And finally, Caroline, first of all, well done for being on public transport. But she's asking about the effect of eco-labels on competition. Yes, although in my experience, where you're requiring an eco-label, let's say it's in a cleaning services contract, it's not really something that would limit competition or be a barrier to small and medium-sized enterprises. Effectively, if you're asking for eco-labeled products, they are going to pass on that cost to you if indeed they have a higher cost as part of the price. And provided you're not being too overly specific in terms of the eco-label, and you are allowing different ones to be put forward, generally it's not something that I would see as a barrier to competition, but obviously it depends a bit on the nature of the contract.
Fantastic. Thank you very much indeed. Chris, your thoughts on the discussion and the question?
Sure, and I just some quick reflections on the U.S. that new U.S. rule that I mentioned was published on April 22. Interestingly, so when everybody outside the U.S. talks about sustainability, the conversation can quickly veer into social justice issues and economic issues. That final rule re-narrows federal sustainability. So in the U.S. context, when we talk about sustainability, be exclusively environmental, social justice, and economic issues are dealt with through a separate track. Abby's point about the subnational experience, really important. In fact, there was a comment in the Federal Register notice where someone said, hey, shouldn't we look at the experience of the state and local level? The regulators essentially ignored that comment and did not take into account our subnational experience. With regards to eco-labels, Caroline's question, and I think it says everything about my relationship with Caroline, that I'm sitting in a car and she's on public transport. God bless her for doing that. In terms of the eco-labels, the Americans are not following the standards laid out in the Max Havelaar case by the Court of Justice for the European Union, which is reflected, I think it's Article 39 of the directive on eco-labels. Very, very important requirements regarding transparency in the regulatory process. The Americans are just not doing that. The Europeans are well ahead of the Americans. That's something to be conscious of in the trade negotiations. What I'm waiting to hear from Peo on is the whether or not this issue of almost conscious ignorance regarding sustainability, environmental sustainability. I'm supervising a thesis of a student, a very dear student, who's based in Tanzania. He went through our program. He writing about sustainability in sub-Saharan Africa. There's no mention at all of environmental sustainability. I was training last week in Turin. I was training at the UN facility there in Turin. There was a pitched battle between the students in the room, between the sub-Saharan Africa and students who were from other parts of the world who took environmental sustainability in a different way. The issue, just to quickly review on this issue of contract administration, the key on the contract administration will, if these obligations are to be honored in the American context, it'll be the knife will be the False Claims Act, the fraud liability, and that'll turn an important part on whether or not the agencies themselves take this seriously. Because if the agencies don't make this a condition for payment, then it's very difficult for a whistleblower or a civil Justice Department lawyer to argue that in fact there should be the basis for fraud liability. The last thing is on bid challenges. Very interesting that this final rule I've been talking about that talks about really forces everybody into a new eco-label reality. It really forces all of that discussion into a pre-award stage, which means in essence that if there's going to be some teeth to all this, there have to be bid challenges brought pre-award. That's very unlikely. Our experience under accessibility standards for IT accessibility, to our surprise, there were 0 bid challenges on that point when those were put in place early in the century. And it's the he is without sin cast the first stone. It's the vendors will be very concerned about raising bid challenges regarding sustainability requirements for fear of being challenged on their own sustainability capabilities. Thanks very much, Anne.
Fantastic, thank you. And Hugh, your reflections on the discussion so far.
Thanks, Anne. I think I'll start with your question about this integration between different regulatory regimes and areas, and I think that is really a critical point. And I think often when we think about the procurement regulatory regime or just the procurement system altogether, we should probably start to apply some of the things that we are preaching others to do to our own discipline and our own practice, and that is to apply a whole life cycle approach to all of this. Because I think one of the things that we're missing in practice is we're not connecting the dots between different dimensions of the broader state that plays into procurement decisions. And with that, I mean, for example, thinking about the effect, and this is going to Caroline's point, for example, the effect on cost if you are going to pursue an environmental commodity and you're going to use an eco-label for that. And at the budget level, already integrating that into the budget allocation, because at that level, there's a policy commitment to it. And I think, you know, one can follow that method, that kind of thinking through the entire process. And I think that's the area where there's a lot of work still to be done, for us to think through how do these things impact across the board, and how do we then create the correct incentives and address blockages and challenges in the system at the right place, so that later on, when a procurement official sits at a table and must take a procurement decision, it's not an insurmountable problem at that stage. So I think you're absolutely correct. This is an area where there's a lot of interaction, and we need to be much more intentional and mindful of the implications thereof if we're going to get traction in this area. Then some of the other points, for me, I think most of these points, eco-labels, the appetite amongst procuring officials to do this additional work, the capacity issues, the question around other policies that can achieve the same objective. For me, it all really comes down to the holy grail of public procurement, which is value for money, and then really, truly starting to interrogate what do we mean with value in that age-old cost benefit or value cost trade-off? Because it seems to me that we've not made a lot of progress in really working on how we understand value in this space. And here, I think the environmental is probably the most important one. Because I think if we start to really integrate a proper value proposition based on climate change, for example, into our consideration of value for money in public procurement, to me, it changes the narrative completely. Then value for money becomes something completely different. And I think that is an important consideration to have. On the question around the extra work, the additional effort that will be required and the capacity needed for that, I think it's really important there to work, you know, to use a very trite term, to work smarter, not harder. What we've learned in South Africa with our very big social policy experiment has been to really take a lot of that work out of the hands of individual procuring officials. You cannot expect them to do it. You cannot expect them to get it right. It must be done elsewhere. And what you really want to do is you want to build a regulatory regime that will, in a focused way, do that kind of upfront work as well as the back-end contract management work, and allow individual procuring officials to simply rely on that. So they don't have to do it in every single transaction. They don't have to have the capacity themselves. They just plug into a system that's being managed and run elsewhere. And I think that is really one of the ways that one should think about it. I mean, I see Malcolm has made this point about sustainability or zero carbon champions. I think that is a perfect example of the type of thing that we should start to think about, that can then lead procuring officials to take the right decisions in their space, but without expecting of the procuring official to be able to really understand that. Otherwise, I fear that the capacity issue is just going to be insurmountable. We're just never going to get beyond that. So for me, I think that is a critical consideration. Thanks, Anne.
Fantastic. Thank you very much indeed. So a big thank you to our three panelists for really interesting presentations. Thank you to our audience for their comments and questions. And just before we wrap up, I'm going to hand over to Rory, who I think might like to say a little bit about the Sparks project.
Hi, thanks very much. So POGO has been away for a couple of months and now we're back. So I wanted to tell you a little bit about what we're going to be doing in the Oxford POGO Club over the course of the next year. So there are really two strands. One strand will be looking at the UK's new Procurement Act 2023, which will be coming into force this year. We'll be looking at areas like innovation and open contracting. There is a national action plan related to open government that has some open contracting commitments in it for the UK that sort of pair well and are in parallel with the Procurement Act, so we'll be looking at that. Some of that involves the new platform that will be introduced in the UK, as well as looking at data use. So that's one strand. Another strand that we have is that related to Sparks. Sparks is the Sustainable Public Procurement Applied Research and Knowledge Sharing Initiative. So we have some funding from the University of Oxford's John Fell Fund and the Oxford Policy Engagement Networks to engage with academics and practitioners to co-design some research on green public procurement and specifically net zero goals in government procurement. So this session is an example of that. We will be wanting to work with partners, including many of the people here, to co-design and seek funding for some kind of net zero in government contracts policy implementation observatory. So if this sounds interesting to you, please get in touch. We're trying to build an observatory and co-design a project that looks at the implementation of net zero policies over time around the world and at different levels of government. So we're thinking about things like a survey of professionals over time, looking at the different roles in different places for implementation, doing some data analysis together, thinking about some fellowships. So if this is interesting, please get in contact. We're having a session next month. So POGO sessions, Oxford POGO Club sessions, are normally, have been traditionally at the end of, the last Tuesday of the month at about 4 p.m. UK time, last Tuesday of the month, 4 p.m. UK. And we're going to try and get back into that habit. So the next session next month, we'll be looking at the ways in which we can compare different types of government units. And then in June, we're going to be having an in-person symposium with some kind of hybrid POGO session on the Tuesday, the 25th of June. And so look forward to your participation in that. One of the things I'm really excited about is that we're trying to support bringing together some practitioners from Belfast and Northern Ireland, Cardiff in Wales, and Edinburgh in Scotland, maybe some others around the UK, to come together to talk about some of these issues and co-design this with us. So a lot of those folks have been involved in some workshops that we did in March 2023. Apologies to them for not getting back to them really and engaging with them enough on the work that was done before. We're going to get back to that beginning with this symposium in June. So lots of opportunities to engage. Chris mentioned the May session that he's got on the US EU catalog. The Sapiens Network is having a conference in June, and the Oxford Government Outcomes Lab is having their social outcomes conference in early September. So all those things are available online on the various websites. Thank you very much. Hopefully that's a helpful update. Anne?
Fantastic. Thank you very much indeed. So there's lots more stuff coming up, and we hope to see some or all of you at some of those events. So thank you once again to our panel, and thank you everyone else for coming along. That closes our POGO session for today. If anyone would like to hang out and have an informal chat with the panelists, do please feel free to stay on the line. It's a bit like waiting in the room after the session has ended, just to say hello at the end. But the formal proceedings and the recording are now coming to an end.